We're in session and cause number 326-246. The case is styled the state of Texas versus Glenn M. Umholtz.
Yes, sir.
Umholtz.
Umholtz.
Okay, how you doing, Mr. Umholtz?
Well, sir, how about yourself?
I'm doing fine, thanks for asking. Mr. Umholtz, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, you may put your hand down. Mr. Umholtz, you're represented here by your attorney, Mr. James Macon. Mr. Macon, how are you doing?
I'm doing fine, Your Honor.
That's good. Mr. Macon, do you waive a record?
I do.
Okay. Mr. Umholtz, I have before me an information that alleges that on or about October 13th of 2019, while you're in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Umholtz, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Umholtz, how do you plead guilty, not guilty, or no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you're guilty?
Yes.
Okay, Mr. Umholtz, I have before me a document that is titled the misdemeanor plea admonishment. It is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Umholtz, oh, he didn't initial it. He got it. Guilty.
I'm just having a great one.
Oh, maybe they,
I do remember initially.
Because I always try and check.
sometimes if you touch
The tablets don't.
this,
like this.
just, there's a little thing on this finish. If you push that in, it erases it. You'll see it, but it won't go on. Yeah, when it comes back to me, you won't be able to see it. Okay, now, Mr. Umholtz. On page 2 of this document, there are 2 sets of initials, your attorney initials and your initials. Did you initial this document on the line that says guilty?
Yes, sir.
And on page 3 of the same document, Mr. Umholtz, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
And on the next document, which is the trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature above the line that's titled defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box check states that you're waiving your right to appeal. Do you understand that?
Yes, sir.
Okay. Mr. Umholtz, I also have before me a document that is titled the discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature above the line that's titled defendant?
Yes, sir.
Mr. Umholtz, prior to signing and initialing these documents that I have just mentioned to you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment. State, you like to offer State's 1?
Yes, Your Honor.
Any objections?
We have no objection to State's 1.
No objections. State's Exhibit Number 1 will be admitted. Mr. Macon, you've advised in counsel, Mr. Umholtz, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Umholtz, your attorney, Mr. Macon, has advised in counsel you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Umholtz, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor.
What is that agreement?
If the agreement is for 180 days, probated over 1 year, a $750 fine, 80 hours community service, DWI education, drug and alcohol assessment, and interlock device.
Okay, Mr. Umhost, the state is offering that you serve 180 days in Jefferson County Jail. However, you will not have to serve any time in Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $750 plus court costs. And the court costs in this case, well, the total fine and court costs in this case is $1,202. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to pay the Jefferson County DWI education class an initial evaluation fee of $125. On the day of the plea, should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you would have to pay each month while you're on probation, is $185 per month. Mr. Umhost, would you be able to pay the $185?
Yes, sir.
Mr. Umhost, you'll also be required to perform 80 hours of community service, attend and complete a DWI education class, have a drug and alcohol assessment, and install a DWI interlock device on any vehicle that you own or operate. You'll also be required to adhere to the other standard terms and conditions of probation. Mr. Umhost, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes,
And do you accept the state's offer?
I do. Yes, sir.
Okay, Mr. Umhost, I will follow the plea bargaining agreement that you have entered into with the state. Mr. Umhost, you can stand on the X next to your attorney. And Mr. Umhost, you're gonna follow the directions of a clerk, and when you finish following her directions, you'll be free to go. You have a blessed day.
Yes, sir.
And Mr.
Thank you, Your
Macon, you'll be free to go as well, and you have a blessed day.
Mhm.
Put your right hand on the scanner. Sign on the pen pad. You won't be able to see it, but I can see it on my screen. Your turn, Mr. Megan. You raise your right hand for me. Do you swear you've never been convicted and given deferred or straight probation in this state or any other state? And you have no other pending criminal charges against you?
No.
Here is the paperwork. Let's report to probation.
Okay, you have a blessed day.
Thanks, sir.
Y'all take care. Thank you, Judy.
All right, thank you.
You can go ahead on and get the individuals in for arraignment. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here. You have been asked to come to court today for an arraignment. What the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and the options that you have regarding your case. Now, your case that you have in this court is a misdemeanor case. We only handle misdemeanor cases. Criminal cases are divided into felonies or misdemeanors. Felony cases are handled in the district court, but the misdemeanor cases are handled in the county court, like this is County Court at Law number 2. Now, with your misdemeanor case, the range of punishment, that is what you can get as punishment for your case. If you have our cases are divided into Class A misdemeanor, Class B misdemeanors, or Class C misdemeanors. Now, the Class C misdemeanors are cases that are handled in the JP court or the municipal court. However, when they are appealed from those courts, then we handle those cases. The punishment range for a Class C misdemeanor is a fine only. You only can get a fine. You cannot be given any jail time. For a Class B misdemeanor, which is the next step up, the range of punishment is anywhere from 0 days to 180 days, which is 6 months in the county jail, a fine from $0 to $2,000, or you can be given both such fine and confinement. For a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is anywhere from 0 days to 365 days in the county jail, which is a year, or you could be given a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may qualify for probation. There are 2 types of probation that a person can get. You could either get what is called deferred adjudicated probation. Normally was unadjudicated probation. We refer to it as deferred adjudicated probation. Or you could get the regular probation, which is adjudicated probation. Now, the difference between the 2 are as follows. With the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, the case will be dismissed and you may qualify for a non-disclosure. What a non-disclosure is it means that we cannot disclose the fact that you was on deferred adjudication to the general public. However, if you violate your unadjudicated probation, the state can file a motion to revoke your probation. If that happens, then you'll be entitled to have a hearing. And if the court finds that you have violated your probation, then the court can give you a conviction. And if you get a conviction, your case will not be dismissed and you cannot get a non-disclosure. Now, for the regular probation or the adjudicated probation, it does result in a conviction on your record as soon as you get on probation. However, there's something that is called judicial clemency, which means that the court can set aside that conviction, but a couple of things needs to happen first. First of all, you need to successfully complete the probation. Next, there cannot be any more time left on the probation, and then the court has to discharge you off of the probation. And if those things happen, then the court can allow you to come back in the court to withdraw, which means to take back your plea of either guilty or no contest. And any complaint, affidavit, or information that has been filed against you will be set aside. And if that happens, then you will no longer have a conviction, and then you can truthfully say that you have not been convicted in this case. However, if you get a subsequent conviction in another case and it's brought to the court's attention, then this case can be revived, resurrected, or brought back up, and it could be used against you. And if you try to get a license with CPS, they can deny giving you a license, or if you have a license, they can suspend or revoke that license. Now, you have rights, other rights as a defendant in a criminal case. Now, the paperwork that has been handed out to you informs you that you have a right to have this. I think the paperwork that has been handed out states that you have 3 options. And the paperwork is titled Judge's Explanation of Rights to Defendants Without Attorney. And it reads, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor, that's the assistant district attorney, about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states defendant's choice. Mark your initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you have already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. And if your choice is, well, if you've already hired or if you've already been appointed, a court-appointed attorney, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney to represent yourself, then you will put your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign at the bottom of the document where it says defendant, and you will place today's date, which is October 12th of 2021. Now, if you are representing yourself, you're waiving your right to attorney and representing yourself, then you will have to sign the second, read and sign the second page, and I will go with you. And the second page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 12th day of October 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you'll sign on the line that says defendant, and you'll place today's date, which is October 12th of 2021. Now, also as a defendant in a criminal case, you have other rights. Another right that you have is you have a right to have a trial by jury. And what this gentleman is sitting in that area, we call that area the jury box. That's where the jury sits. 6 citizens from Jefferson County will be selected to sit on your case. And they will decide after listening to all of the evidence whether or not you are guilty or innocent. You also have a right to waive or give up your right to have a trial by jury. That simply means you have a right not to have a trial by jury. And if you do so, and if you still want your case to go to trial or have a trial, then your case will just come before the judge without a jury. We call that a bench trial. Now, if you would like your case to come before the judge, if you enter a plea of guilty and no contest, it can come before the judge in one of 2 ways. If you have an agreement with the district attorney's office, we call that a plea bargain agreement, then you will have what is called an agreed plea. Or if you and the district attorney, and you and the district attorney, or your lawyer and the district attorney cannot agree on a plea bargain agreement, you still want your case to come before the judge, then it will come before the court or the judge in what we call an unagreed plea. Now, you also have a right to have witnesses to come to court to testify for you or against you. You have a right to ask some questions. We call it direct examination or cross-examination. Witnesses, they sit in this chair right there. We call that the witness stand. Now, you also have a right to waive or give up your right to have witnesses to come to court. And that simply means you will not be calling any witnesses to testify in your case. However, the state will be calling witnesses to testify in the case that they have filed against you. You have a right to waive or give up that right, as I said earlier. If you do so, the state will be calling witnesses. However, you will not be calling witnesses on your behalf. Now, you also have a right against self-incrimination. Sometimes you hear people say, I take the fifth. What that basically means, you have a right to not to testify in your case. The state or no one else can force you to testify. Now, you also have a right to waive or give up that right. And by doing so, you are stating that I know I have a right not to testify, and I'm waiving that Fifth Amendment right, and I want to testify. And so you will be testifying if you waive your right against self-incrimination. You also have a right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you. If you have an attorney, your attorney will be given access to that evidence. If you are representing yourself, you'll be given access to that evidence. And when the evidence, it could either be documents, witness statements, videos, or things of that nature. Also, you have a right to, now, as I said earlier, you have a right to have discovery in your case. Next, if you are represented by an attorney, your attorney will have an opportunity, as I said earlier, to talk to the prosecutor to see if they can work out a settlement on your case. If they are able to work out a settlement, we call that a plea bargain agreement. Or if you're representing yourself, you'll have an opportunity to talk to the prosecutor to see if you can work out a settlement. And we still call it a plea bargain agreement if you are able to work out a settlement. If you are not able to work out a settlement, no problem. Then if you still want your case to come before the court or come before the judge, you still can come before the judge on what is called an unagreed plea bargain agreement. Now, if you have an agreement with the state, I do not have to follow that agreement. However, if I do not follow that agreement, you'll have a right, or you'll be entitled to withdraw, which means to take back your plea. That simply means you be saying, Judge, you're not following the plea bargain agreement that I made, I take back my plea. You have a right to do that. Now, if the court does follow your agreement, and if you decide within 30 days that you would like to appeal your case, and what an appeal is, you'll be asking a higher court than this court to look at your case to see if whether or not you've been wrongfully convicted, whether or not we committed an error by convicting you. And that higher court is located right above us on the 3rd floor. It's called the Ninth Court of Appeal. They will review your case. They will decide whether or not you are, you've been wrongfully convicted, or whether or not we committed an error by convicting you. Now, they can either grant your appeal or deny your appeal. If they grant your appeal, then they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then within 30 days of them denying your appeal, you will have a right to appeal it to another court, to a higher court than the Ninth Court of Appeals. That higher court is called the Texas Court of Criminal Appeals. It's located in Austin, Texas. It is the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. Pro se means you'll be filing it on your own without the assistance of a lawyer. And you'll be asking them to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court committed an error by convicting you. They can either grant or deny your pro se petition. If they grant your pro se petition, they could just simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial, or they can, if they deny your appeal, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you can enter one of three types of pleas. You can enter a plea of guilty, not guilty, or no contest. Now, if you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or if you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting those charges. Now, everyone here who's here for arraignment, you have been arrested. And every day that you spent in jail, that time can be used as credit towards your punishment. So for example, if you or your attorney talk to the prosecutor and the prosecutor is offering to settle the case for 5 days in jail, you've already spent 5 days in jail, that simply means you will not have to spend any more time in jail because you'll be given credit for time served. Now, if they're offering to pay you a fine, if they're offering to the punishment as to be a fine and court costs, let's say you spent 5 days in jail. Every day that you spent in jail is credited as $100 per day. So if you spend 5 days in jail, that's $500. So if they are offering a fine of $500, fine and court costs of $500, you spent 5 days in jail, you won't have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, your fine and court costs will be taxed and retired, which means you won't have to pay it. Now, if you spent less time than what they're offering, for example, they're offering $700, you spent 5 days in jail, that means you'll have to pay $200. Now, if you can't pay the money that day, then we could put you on a payment plan. You can pay it in installments. But let's say you cannot pay it in installments, then we can convert the fine and court costs to what is called community service. Now, every hour that you do in community service, you get $12.50 that will go toward your fine and court costs. So if you work 8 hours of community service in one day, that's $100 that will go toward your fine and court costs. Okay. Now, next, Jefferson County has a program that is called pretrial diversion. It's for first-time offenders, people who have not been in trouble before, and it cannot be for, and basically what happens is with pretrial diversion, your case is dismissed and then it could get expunged from your criminal record. What that expunged means, it can be wiped off, deleted, or erased from your criminal record. Now, in order to qualify, it has to be your first offense. Second, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest, and you would have to have an attorney to assist you at getting into the program. And as I said earlier, once you get into the program, case is dismissed, you complete the program, you can get it expunged, erased, wiped off, or deleted from your record. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has a program that is called Veterans Court. And with Veterans Court, it's part of the pretrial diversion program, and it operates the same way, in that you get into the program, complete the program, case dismissed, you can get it expunged from your record. Only thing you have to do is have it, the only requirement is you have to have been a member of one of the branches of the United States military. Now, this court has a program as well that is called the Community Safety Initiative. It's a program that I started in March of 2017, within 100 days of being a judge in this court. And that program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. And the way the program works is we address the issue of what is called recidivism. Recidivism is when people commit crimes over and over. And so the way we address that is through partnerships that we have in the community with our various organizations and centers. For example, we address mental health issues. We have a partnership with the Spindletop Center. We have some individuals from Spindletop Center who's sitting in the jury box, and they will come later on to you and talk to you about their program. But basically what they'll do, they'll be able to do a private interview in our jury room. They will also, the Spindletop Center has the capability of doing what is called an assessment. They could develop a treatment plan, either outpatient or inpatient, to address your mental health needs. And individuals who have problems or issues with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. And with that program, individuals are interviewed, they're given screenings, and they could develop a treatment plan, either outpatient or inpatient treatment to address your alcohol or drug addiction needs. Also, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of the areas that you select, one of those 3 areas that you select, then they will assist you at getting a job in one of those, in the area that you're trained in. And if you do not have, or if you have not graduated from high school, they can assist you with getting a GED, graduate equivalency diploma. And so all of those programs, as I said earlier, are designed to address the issue of recidivism. And the reason why I say that is because there's a cycle, and the cycle starts off with individuals who do not have an education, can't get a job. They can't get a job, they normally turn to drugs and alcohol. Once they turn to drugs and alcohol, they eventually commit a crime. And once they commit a crime, they eventually get caught and do time. And once they do time, at some point, they're going to get out. And once they get out, they're back into the cycle. And so we break the cycle with our CSI program. Because I tell people this all the time, when you come to County Court at Law Number 2, we do not have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in Jefferson County. We also, with our program, we do not just arrest the problem, we address the problem. And we produce productive people with the program that we have with that CSI program. If you're interested in the program, just let us know. We have brochures that we can give to you where you can contact CICE to get into their job training, job placement program. And we have a deputy, our mental health deputy, Deputy Hinton, who is going to come to you and talk to you about the program that they have at the Spindletop Center. Deputy Hinton.
Thank you, Your Honor. Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. I'm here with 2 of my partners, Mrs. Kennedy and Mr. Hebert. They're both qualified mental health professionals with Spindletop. And the reason we're here in the courtroom is the judge has graciously allowed us into the courtroom because he cares about every single person and he wants to provide the assistance they need should this apply to y'all. What we have found is a lot of people who cycle in and out of the criminal court have underlying issues such as either mental health issues or substance use disorders. We believe if we can address these underlying issues, we can get you out of the cycle of arrest so that you never have to come back to court again. Now, there's 2 problems we find in presenting this in the courtroom is, first of all, we don't know who may be having these underlying issues unless you tell us. That's why we're asking you this morning, if you will, share that with us. And we don't know, secondly, we don't know if you don't tell us. So we're asking you to share the information with us so we can provide you the resources, give you direction, even advocate on your behalf with Spindletop to get you the services that you need in particular, fit your particular situation. Now, we have a brochure here. I'd like to, at the very least, make sure that you have one of these. On here, it tells you a little bit about what our system does, what our program does. And on the front, it has a 1-800 number. Should you find yourself in an unsafe place at any given time out there during the week, you can call this number and get help immediately to help you. We want to make sure that we put this in every one of y'all's hands before y'all leave here today. Does anyone have any questions? One more thing I want to add. Maybe this doesn't apply to y'all. Maybe it applies to a family member. We would love to visit with y'all about that too and give you the resources so that you could help the family member and get them directed toward it. And we'd be glad to contact them through y'all, of course, to try to reach out to them for that help as well. Again, any questions? Thank y'all very much. You're very kind, very attentive. Thank you.
Okay, thank you, Deputy Hinton.
Thank you, Your Honor.
Okay, ladies and gentlemen, the paperwork that you signed, we're gonna have someone to come by from the court and pick that paperwork up from you. It's gonna take us a few minutes to go through it and so that we can place everyone in the proper category. And so if you need to go to the restroom, our restrooms or outside the door, in the lobby area. Now, do not leave the courthouse, because if you leave the courthouse, your bond gonna be forfeited, your bond get forfeited, that means that you have a warrant issued for your arrest. So, but you have some time to go to the restroom if you need to go to the restroom. Now, the gentleman right there, at one point, I saw your hand raised.
Yeah, is the prosecutor, there to?
Yeah, today, if they, you're talking about to make offers and stuff like that?
Discovery, and also I want to make a movement for dismissal of my charge.
Well, you need to talk to the, if you are representing yourself, you'll have an opportunity to talk to the prosecutor today.
And you can't go outside and smoke?
Well, put it like, okay, you probably can, but just make sure you do not leave the courthouse. I mean, the courtroom, the courthouse area, because as I told you earlier, it's gonna take us a little time to go through the paperwork that we need.
Just don't drag my heels.
Yeah, we all, yeah. Yes, ma'am.
I was supposed to see you earlier, but I was in this court.
Okay, yeah,
How long do you think this will-
just hold on. It's gonna take us a little while to get through the paperwork. Okay? Well, just hold on. We'll get to you. Okay, we'll be in recess.